Franchises PLDT City of Davao. PLDT is liable for the local franchise tax. Section 137 does not state that it covers future exemptions. The grant of taxing powers to LGUs in the Consti and the LGC does not affect the power of Congress to grant exemptions in the future. The only legal effect of the constitutional grant to local governments, in interpreting statutory provisions on municipal taxing powers, doubts should be resolved in favor of municipal corporations. City Government of QCV Bayantel. Facts: Bayantel is a legislative franchise holder under RA 3259 to establish and operate radio stations for domestic telecommunications, radiophone, broadcasting and telecasting. Of relevance to this controversy is the tax provision of Rep. Act No. 3259, embodied in Section 14 thereof, which reads: Section 14. The grantee shall be liable to pay the same taxes on its real estate, buildings, and personal property, exclusive of the franchise, as other persons or corporations are now or hereafter may be required by law to pay. The grantee shall further pay to the Treasurer of the Philippines each year, within 10 days after the audit and approval of the accounts as prescribed in this Act, 1.5% of all gross receipts from the business transacted under this franchise by the said grantee. The LGC took effect and granted the LGUs within Metro Manila the power to levy on real properties. On July 20, 1992, barely few months after the LGC took effect, Congress enacted RA 7633, amending Bayantel's original franchise. The amendatory law contained an in lieu of taxes clause. In 1993, the government of Quezon City, pursuant to the taxing power vested on local government units by Section 5, Article X of the 1987 Constitution, infra, in relation to Section 232 of the LGC, supra, enacted City Ordinance No. SP 91, S. 93, otherwise known as the Quezon City Revenue Code. 5. Imposing, under Section 5 thereof, a real property tax on all real properties in Quezon City, and, reiterating in its Section 6, the withdrawal of exemption from real property tax under Section 234 of the LGC, supra. Furthermore, much like the LGC, the QCRC, under its Section 230, withdrew tax exemption privileges in general. Conformably with the city's revenue code, new tax declarations for Bayantel's real properties in Quezon City were issued by the city assessor and were received by Bayantel on August 13, 1998, except one which was received on July 14, 1999. Meanwhile, on March 16, 1995, Rep. Act No. 7925, otherwise known as the Public Telecommunications Policy Act of the Philippines, envisaged to level the playing field among telecommunications companies, took effect. Section 23 of the Act provides an equality clause. On January 7, 1999, Bayantel wrote the Office of the City Assessor seeking the exclusion of its real properties in the city from the roll of taxable real properties. With its request having been denied, Bayantel interposed an appeal with the LBAA. And, evidently on its firm belief of its exempt status, Bayantel did not pay the real property taxes assessed against it by the Quezon City government. On account thereof, the Quezon City Treasurer sent out notices of delinquency for the total amount of P43,878,208. 18. Followed by the issuance of several warrants of levy against Bayantel's properties preparatory to their sale at a public auction set on July 30, 2002. Threatened with the imminent loss of its properties, Bayantel immediately withdrew its appeal with the LBAA and instead filed with the RDC of Quezon City a petition for prohibition with an urgent application for a temporary restraining order and/or writ of preliminary injunction. The RDC then rendered judgment exempting Bayantel from taxes. Issue: 1 Buy and Tell failed to exhaust administrative remedies. Held no ratio with the reality that Buy and Tell's real properties were already levied upon on account of its non-payment of real estate taxes thereon. The court agrees with Buy and Tell that an appeal to the LBAA is not a speedy and adequate remedy within the context of the aforequoted Section 2 of Rule 65. This is not to mention of the auction sale of said properties already scheduled on July 30, 2002. Moreover, one of the recognized exceptions to the exhaustion of administrative remedies rule is when, as here, only legal issues are to be resolved. In fact, the court, cognizant of the nature of the questions presently involved, gave due course to the instant petition. As the court has said in Thai v. Tramp, although as a rule, administrative remedies must first be exhausted before resort to judicial action can prosper, there is a well-settled exception in cases where the controversy does not involve questions of fact but only of law. Lest it be overlooked, an appeal to the LBAA, to be properly considered, required prior payment under protest of the amount of P43,878,208. 18, a figure which, in the light of the then prevailing Asian financial crisis, may have been difficult to raise up. Given this reality, an appeal to the LBAA may not be considered as a plain, speedy, and adequate remedy. It is thus understandable why Buy and Tell opted to withdraw its earlier appeal with the LBAA and, instead, filed its petition for prohibition with urgent application for injunctive relief in civil case No. Q02-47292. The remedy availed of by Buy and Tell under Section 2, Rule 65 of the Rules of Court must be upheld. Issue: 1 Buy and Tell's real properties in Quezon City are, under its franchise, exempt from real property tax. Held, no ratio. The lower court resolved the issue in the affirmative, basically owing to the phrase exclusive of this franchise. Found in Section 11 of Buy and Tell's amended franchise, Rep. Act No. 7633. To petitioners, however, the language of Section 11 of Rep. Act No. 7633 is neither clear nor unequivocal. The elaborate and extensive discussion devoted by the trial court on the meaning and import of said phrase, they add, suggests as much. It is petitioners' thesis that Buy and Tell was in no time given any express exemption from the payment of real property tax under its amendatory franchise. There seems to be no issue as to Buy and Tell's exemption from real estate taxes by virtue of the term exclusive of the franchise qualifying the phrase same taxes on its real estate, buildings, and personal property, found in Section 14, supra, of its franchise, Rep. Act No. 3259, as originally granted. The legislative intent expressed in the phrase exclusive of this franchise cannot be construed other than distinguishing between two sets of properties, be they real or personal, owned by the franchisee, namely, those actually directly and exclusively used in its radio or telecommunications business, and those properties which are not so used. It is worthy to note that the properties subject of the present controversy are only those which are admittedly falling under the first category. To the mind of the court, Section 14 of Rep. Act No. 3259 effectively works to grant or delegate to local governments of Congress's inherent power to tax the franchisee's properties belonging to the second group of properties indicated above, that is, all properties which, exclusive of this franchise, are not actually and directly used in the pursuit of its franchise. As may be recalled, the taxing power of local governments under both the 1935 and the 1973 constitutions solely depended upon an enabling law. Absent such enabling law, local government units were without authority to impose and collect taxes on real properties within their respective territorial jurisdictions. While Section 14 of Rep. Act No. 3259 may be validly viewed as an implied delegation of power to tax, the delegation under that provision, as couched, is limited to impositions over properties of the franchisee which are not actually directly and exclusively used in the pursuit of its franchise. Necessarily, other properties of buy and tell directly used in the pursuit of its business are beyond the pale of the delegated taxing power of local governments. In a very real sense, therefore, real properties of buy and tell, save those exclusive of its franchise, are subject to realty taxes. Ultimately, therefore, the inevitable result was that all realties which are actually, directly, and exclusively used in the operation of its franchise are exempted from any property tax. Buy and tell's franchise being national in character, the exemption thus granted under Section 14 of Rep. Act No. 3259 applies to all its real or personal properties found anywhere within the Philippine archipelago. However, with the LGCs taking effect on January 1, 1992, buy and tell's exemption from real estate taxes for properties of whatever kind located within the Metro Manila area was, by force of Section 234 of the Code, supra, expressly withdrawn. But, not long thereafter, however, or on July 20, 1992, Congress passed Rep. Act No. 7633 amending buy and tell's original franchise. Worthy of note is that Section 11 of Rep. Act No. 7633 is a virtual reenactment of the tax provision, i.e., Section 14, supra, of buy and tell's original franchise under Rep. Act No. 3259. Stated otherwise, Section 14 of Rep. Act No. 3259, which was deemed impliedly repealed by Section 234 of the LGC, was expressly revived under Section 14 of Rep. Act No. 7633. In concrete terms, the realty tax exemption heretofore enjoyed by buy and tell under its original franchise, but subsequently withdrawn by force of Section 234 of the LGC, has been restored by Section 14 of Rep. Act No. 7633. The court has taken stock of the fact that by virtue of Section 5, Article X of the 1987 Constitution, local governments are empowered to levy taxes. And pursuant to this constitutional empowerment, juxtaposed with Section 232 of the LGC, the Quezon City government enacted in 1993 its local revenue code, imposing real property tax on all real properties found within its territorial jurisdiction. And as earlier stated, the city's revenue code, just like the LGC, expressly withdrew, under Section 230 thereof, supra, all tax exemption privileges in general. This thus raises the question of whether or not the city's revenue code pursuant to which the city treasurer of Quezon City levied real property taxes against buy and tell's real properties located within the city effectively withdrew the tax exemption enjoyed by buy and tell under its franchise, as amended. Buy and tell answers the poser in the negative, arguing that once again it is only liable to pay the same taxes as any other persons or corporations on all its real or personal properties, exclusive of its franchise. Buy and tell's posture is well taken. While the system of local government taxation has changed with the onset of the 1987 Constitution, the power of local government units to tax is still limited. As we explained in Mactan Cebu International Airport Authority, the power to tax is primarily vested in the Congress. However, in our jurisdiction, it may be exercised by local legislative bodies. No longer merely by virtue of a valid delegation as before, but pursuant to direct authority conferred by Section 5, Article X of the Constitution. Under the latter, the exercise of the power may be subject to such guidelines and limitations as the Congress may provide, which, however, must be consistent with the basic policy of local autonomy. Clearly then, while a new slant on the subject of local taxation now prevails in the sense that the former doctrine of local government units' delegated power to tax had been effectively modified with Article X. Section 5 of the 1987 Constitution now in place, the basic doctrine on local taxation remains essentially the same. For as the court stressed in Macton, the power to tax is primarily vested in the Congress. This new perspective is best articulated by Fr. Joaquin G. Bernays, S.J. himself a commissioner of the 1986 Constitutional Commission which crafted the 1987 Constitution, thus. What is the effect of Section 5 on the fiscal position of municipal corporations? Section 5 does not change the doctrine that municipal corporations do not possess inherent powers of taxation. What it does is to confer municipal corporations a general power to levy taxes and otherwise create sources of revenue. They no longer have to wait for a statutory grant of these powers. The power of the legislative authority relative to the fiscal powers of local governments has been reduced to the authority to impose limitations on municipal powers. Moreover, these limitations must be consistent with the basic policy of local autonomy. The important legal effect of Section 5 is thus to reverse the principle that doubts are resolved against municipal corporations. Henceforth, in interpreting statutory provisions on municipal fiscal powers, doubts will be resolved in favor of municipal corporations. It is understood, however, that taxes imposed by local government must be for a public purpose, uniform within a locality, must not be confiscatory, and must be within the jurisdiction of the local unit to pass. In net effect, the controversy presently before the court involves, at bottom, a clash between the inherent taxing power of the legislature, which necessarily includes the power to exempt, and the local government's delegated power to tax under the aegis of the 1987 Constitution. Now to go back to the Quezon City Revenue Code which imposed real estate taxes on all real properties within the city's territory and removed exemptions theretofore previously granted to, or presently enjoyed by all persons. Whether natural or juridical, there can really be no dispute that the power of the Quezon City government to tax is limited by Section 232 of the LGC which expressly provides that a province or city or municipality within the metropolitan Manila area may levy an annual ad valorem tax on real property such as land, building, machinery, and other improvement not hereinafter specifically exempted. Under this law, the legislature highlighted its power to thereafter exempt certain realties from the taxing power of local government units. An interpretation denying Congress such power to exempt would reduce the phrase not hereinafter specifically exempted as a pure jargon, without meaning whatsoever. Needless to state, such absurd situation is unacceptable. For sure, in PLDT City of Davao, this court has upheld the power of Congress to grant exemptions over the power of local government units to impose taxes. There, the court wrote, indeed, the grant of taxing powers to local government units under the Constitution and the LGC does not affect the power of Congress to grant exemptions to certain persons, pursuant to a declared national policy. The legal effect of the constitutional grant to local governments simply means that in interpreting statutory provisions on municipal taxing powers, doubts must be resolved in favor of municipal corporations. As we see it, then, the issue in this case no longer dwells on whether Congress has the power to exempt buy-and-tells properties from realty taxes by its enactment of Rep. Act No. 7633 which amended buy-and-tell's original franchise. The more decisive question turns on whether Congress actually did exempt buy-and-tells properties at all by virtue of Section 11 of Rep. Act No. 7633. Admittedly, Rep. Act No. 7633 was enacted subsequent to the LGC. Perfectly aware that the LGC has already withdrawn buy-and-tell's former exemption from realty taxes, Congress opted to pass Rep. Act No. 7633 using, under Section 11 thereof, exactly the same defining phrase exclusive of this franchise which was the basis for buy-and-tell's exemption from realty taxes prior to the LGC. In plain language, Section 11 of Rep. Act No. 7633 states that the grantee, its successors, or assigns shall be liable to pay the same taxes on their real estate, buildings and personal property, exclusive of this franchise, as other persons or corporations are now or hereafter may be required by law to pay. The court views this subsequent piece of legislation as an express and real intention on the part of Congress to once again remove from the LGC's delegated taxing power, all of the franchisee's properties that are actually directly and exclusively used in the pursuit of its franchise.